if you steal Maggie and somebody takes you to court, for instance, in Nigeria, that particular matter can go all the way to the Supreme Court.
Really?
Yes. Yes. Every petty offense, every dispute, there's no dispute if there's anyway, there are things that you look
So
at
if
constitutionally.
civil cases can get all the way to the Supreme Court, then why is the Supreme Court reserved for governors and presidential cases only?
That's the perception, because those are the cases that make it to the media.
Thanks for joining in. It's an amazing time we're having. Well, one of the editions we've had so far brings us quite a number of conversations that really pushed forward, and I do hope you get the chance to do the same. Welcome to Matters That Matter. Well, they matter because they matter to you. I am Femi D. Amele, and I'm glad to be your podcast host on today's edition of The Conversation. Yes, many of you rely on a lot of issues that go on with the court. You wonder what it's about. Well, we'll break that down all the way through. Thanks to our partners at HBS, Electoral Foundation, that supported our work. And of course, this is produced by Vibing Brands. And yes, you're watching this right now on Volume Pod, one of our partners. So we're glad and excited that you get a chance to watch this. Remember, your comment, your views, your perspective are very much welcome as you follow through. In fact, we are counting on them to make a difference. And yes, because of that, we went in need of two major brains. They are lawyers, but they are excellent when it comes to development sector. They help us to provide perspective to when we get to the courts, when people get to the courts, and we are all watching in the event we get to watch. What are we watching? What are their cases and the likes of that? Well, we're about to find out all about that this very wonderful day. My guest today, Mahmood Yusuf, is a lawyer and a justice reform advocate with over 15 years experience in human rights, development practice, governance, and rule of law. Yes, he's also provided excellent perspective when it comes to conflict resolution, clinical legal education, access to justice, and legal aid. But right now, he holds an important role serving as the programs manager at the Network of University Legal Aid Institutions, NULA, Nigeria. And yes, I do know they have over 48 universities they are working with. That was at 2022. Okay? Now, they do help to fundraise and work around legal issues and develop training materials as much. As you can suspect, there's a lot to his profile, but I'm guessing that he will be living up to who he is as we have this conversation today. My second guest for today would have to be Wise Abraham. No, let me take that again. Abdurrahman. Why do I always mix up Abdurrahman over and over again? But Abdurrahman, thank you so much for coming in. He's a legal practitioner, a senior project officer at NULA as well. He holds a Master of Law degree from Nasarawa State University. As a project officer, he has excelled in effective implementation of NULA projects, provides technical assistance to NULA network of over 50 universities, based law clinics, and of course, promoting access to justice across communities in Nigeria. He also would hold his ground in looking through with profiles in Nigeria. Gentlemen, welcome to the podcast today.
Thank you for having us.
Thank you very much.
All right, let me start off with speaking to Mahmood now. I mean, in every sense of it. And when I think about courts, verdicts, and the likes of that, they are the third major part of our government. But they are standing by to interpret cases that are brought before them, whether weak cases or strong cases, election cases. Give us an idea of why sometimes we end up in courts in the first place.
So thank you very much again, Femi D, for this opportunity to speak. The courts, as it were, is part of the system of governance that we have. So when you look at the governance system, you see there's a legislature, there's an executive, and then the judiciary. The constitutional role of the judiciary is to interpret. It is to interpret and then resolve conflicts. As we know, everyday life, there's bound to be conflict in terms of everyday life, everyday transactions, crimes, and what have you. So this extends to conflict as it regards to governance in the sense that if you look at elections is a governance issue. So when there is issues or conflict with election cases, naturally it goes to the courts as the natural arbiter. So you have situations where the legislature, people vying for legislative office, for executive office, will definitely have to go to the courts, because the court is the constitutional mandated organ of government that resolves conflict between the government and the people, and between people as we say.
And I do hear election tribunal is mainly established under Section 239 of the Nigerian Constitution, and there are many other, even the electoral law backs up the fact that we need this. That means that over the years, it is almost looking like we would always end up in courts, right?
So, like I said, the Constitution gives the courts the rules to play in dispute resolution. So there are different types of dispute resolution. So when you have a civil or criminal matter, you go to the normal court. But the electoral tribunals are special courts that are set up with specific mandate as to how their procedure runs, when their time frame elapses, begins and elapses, and the constitution in the sense that of their composition, if I would use that word. So the election tribunals are different from the regular courts we have, in the sense that they are set up to try election cases, and they have a time frame basically. So it's different from the regular court system that we have, but it also has a constitutional backing as a dispute resolution setup in terms of conflicts where you have electoral conflicts.
And one question quite a number of Nigerians often ask is, I don't like the result, I voted, and that, and that, and that. You hear a lot of that. And people have often asked me that why can't they, who feel that they've been disenfranchised or feel like they've been, usurped their chances, why can't they carry their own case to court and say, for this result, I am disputing. The one at this my poll, I want to do this. Why is the legal system not allowing that?
So, like he said, the electoral disputes are special. They are sui generis. We call them, they have a special procedure on their own. And even though as individuals and as citizens of the country, you go out to vote during elections, you kind of in a way participated in the elections, right? You're the one who, goes out to vote for the candidate of your choice. But the law is that the procedure is that for you to be able to challenge the outcome of an election in an election tribunal, for instance, you have to have participated in the election. Participated in the election in the sense that you either contested the election or you are the political party, because Nigeria, we don't have, the constitution does not provide for independent candidature. So you must have been sponsored by a political party to contest the election. So you are either someone who participated in the election or the political party who participated in the election. And then there's also INEC, who is the arbiter of the election. INEC serves as a referee, if you may, of the election. So these are the parties that the constitution or the procedures for election tribunals allow. It's called the election petition procedure. These are the parties that are only allowed by law to, contest the outcomes of an election. So by the way our laws are designed, an individual who does not, participate in that election
jump in there.
and not just jump there, is what we call, you become a meddlesome interloper. You do not have locus standi to bring a petition before the court. So you must have locus.
Locus standi means that from your
that you
point
have,
or your standpoint, that you have something to lose.
You have something. You have an interest in the matter in the way that the law allows you to have an interest.
And in most cases, political parties, we have about 19 of them in Nigeria, right? Or thereabout. They are the ones that get to say, or alongside with their candidates, if there's any, to say we're totally not following through with the results of this. But then there's also this category of before an election happens, right? Sometimes people start off petitions, election petitions, to say this candidate or this aspirant is not qualified. Walk a typical Nigerian through what that means when they say before an election, I am putting forward that this person is not qualified.
So, like we have with every walk of life, you have certain qualifications. The Constitution provides for certain qualifications, whether it's your educational qualification, your age qualification, depending on the office that you're vying for, and all the other requirements that you need to fulfill before you can stand. It's just like you wanting to go into secondary school. Now, you must have passed certain subjects. You must have reached a certain age before you're allowed admission into. It's the same thing with elections too. You must be qualified in a way. And there are certain situations where people stand for elections with fraudulent qualifications. In some cases, people lie about their age. If you're 45, you need to be 45 before you can contest the presidency, for example, and you're just 40, where you insist on contesting, and you falsify your birth certificate or something like that, and you contest. The person you're contesting against has the right to go to court and say, no, this person is not qualified to participate in this election. But here's where I think what you want sorted out. Those issues are at a pre-election dispute stage. The election hasn't happened. Maybe the primaries is about to happen, or the primaries have happened and you're not fine with the outcomes of the primaries. You're allowed a certain period to go to court and challenge the outcome of the inner workings of the party now at pre-election stage. So you're a member of that political party. You contested, for instance, against a particular candidate who came out victorious, and you're saying, no, this guy came out victorious on fraudulent grounds. He was not qualified to participate in this process in the first place. Or he was qualified to participate in the process, but the process was marred with irregularities at pre-election, before the general election, where you're contesting with other political parties, for instance. Now, so that's a pre-election matter. And people who participated in those pre-election processes as members of that political party have a right to go to court and challenge the outcome of that process.
When I think about challenging the outcome of the process, in fact, one of the things that seems to be, and this is my perception, and this is me, and we strongly want to be able to talk about perception of Nigerians, especially when it comes to judges, to judicial process, and the likes of that. A good number, when in 2019, I don't know if you recall, but I do know that in 2019, there were over 2,000 election tribunal cases, right? And there was another set in 2023, but the numbers have continued to drop. And I fairly think that quite a number of Nigerians often have this vibe that, after all, we know what the judges will say. After all, we know how this. Do you think we're losing faith in our judicial process, and why is that so?
So I'll say yes. There's a loss of trust in the judicial process progressively over the years, because one, I'll say it boils down to the fact that a lot of people don't understand how the judicial system works. And then also, there's a lot of gray areas we have with the electoral laws, as it were.
Do you mind sharing one or two?
So, for instance, if you talk about you give example of the 2019 and the 2023 elections. The 2023 elections was predicated upon the Electoral Act, the amended Electoral Act, that gave INEC the leeway to do electronic transmission of results. That was to curb some of the challenges that was experienced during the 2019 elections, where they said, they were looking at the integrity of the results. So now in 2023, we had a glitch with the with the system, but
Beavers.
that's the beavers,
Beavers, yes,
the
beaver
beavers
version.
that was introduced. But the INEC came out to say that the law does not mandate them to do a live transmission of the result, because that was what
And it's
people-
actually what is in the law,
yes,
right?
that's what is in the law. That was what was predicated upon that. So you see, these technical issues. It's important for us as citizens to understand what the laws are and how the courts apply or interpret these issues. 2023 was very peculiar in the sense that there was a lot of enthusiasm in amongst people. We want to vote. But if you look at the results, you'll see there was a drop in participation. There was this hype in the run up to the elections. People go get your voter
PVC.
your PVC. But the elections, when the election it was not up to the number of people who voted during the 2019 election. So I'll say there's a loss of trust in the judicial system, predicated on a lack of I would say awareness about how the system works. So if we have in-depth understanding, because I believe that is where INEC should that's one failure on the part of INEC. I would really say you need people to understand what the electoral processes are, what the electoral laws says as to how these things are determined, or these things are resolved if we have an issue around it. The courts don't manufacture facts or evidence. The court works with what's
available.
What is being presented to them. And if they view what they have, and there's a preponderance of fact to support what is brought before them, then invariably what they would determine is an affirmative or negative thing. So for me, I believe, building on perception of the general perception of people, there's a loss of trust in the judiciary. Also, based on the fact that the over the years, electoral judgments or decisions have really, there's a lot of inconsistencies in electoral decisions. So I'll give one example. If you look at the Plateau case in 2023, where a whole party had its members excluded from
the ballot papers?
Yeah, from the ballot. They actually contested, and a number of them won. So from the House of Assembly, the National Assembly, House of Representatives, and Senate. And there was an issue based on the fact that it was a pre-election issue that was determined, and the ruling was that the party did not have a structure, and based on that, they could not sponsor candidates to the general elections, but they still went ahead and sponsored candidates who contested and were declared winners. So they went to the first tribunal, affirmed. So up until the Court of Appeal that upheld that the party did not have the structure or the mandate to sponsor candidates to the general elections. So all of those candidates were dropped. But coming to the governorship election, it went through the Supreme Court, and the candidate from that same party that was alleged not to have a structure is sitting as a governor now. So you see the injustice. So people would tend to, at that instance, question, if you say we don't have a structure, and this number of people were excluded or were declared not not fit
Eligible.
eligible to hold the office which they won. And we have, so there's
something not right.
Yeah, there's something that is not right. So these are some of the instances that make people kind of
about the situation.
The people always in instances like this, people would take a step back to, so what is actually the problem here?
And the build up to that level of, should I say, corrosion into confidence into the judicial system is also showing up when it comes to what people say about who is the judge and court jurisdiction. Who is the judge? Where does it come from? How can you review this case? Does he know well enough? People are going after the integrity of judges.
True. I think, and it's part of some of the issues that we highlighted in the course of our work. The procedure, there has been a lot of outcry over the procedure of appointment of judges in the first place. What is the selection process like? How are the judges vetted? I mean, the Constitution, just for a High Court judge, all you need is 10 years post-call experience for you to be constitutionally qualified to become a judge of the High Court, for instance, and there are 15 years for the Court of Appeal and the Supreme Court. But it goes beyond that. There are things like experience that need to be put into place. How much time did you spend in practice? How has your interactions with the law been over the course of time that you've been so qualified? But because the appointment process is shrouded, it's not, people have cried out that it's not very transparent, and there's a lot of nepotism when it comes to the appointment of judges, as opposed to, giving merit more chance in those appointments. You have, in quote, people have suggested that a lot of judges, it's almost like an inheritance type of thing. Once one judge is going out of the system, he nominates a child or a relative or somebody. Over the course of our research, we've seen how one of the chief justices has a nephew here appointed as a judge here, a niece here, a son or daughter-in-law appointed here. And if you look at the whole system in all of the 36 states of the Federation, so you have situations like that where familial loyalty takes, precedence over merit in the appointment of people into the bench. A lot of people have said this has, really put some question marks on the
credibility and
integrity of the process of selecting judges. And when you have people who come to the bench through those type of nepotistic processes, their loyalties are not to the law and the constitution of the state. Their loyalties are mostly to the people who got them to those places in the first place. And that's where situations like political interference and influence peddling come into place. And then they go to affect larger issues of tribunal appointments and all of that. So the selection process, the appointment processes of, getting judges over. We're not even saying that these people, you should not have family. There are arguments that, if they are qualified, why not? We are not saying you shouldn't have family people just because I'm a judge.
But should we even have family people?
No.
Shouldn't that be...
judge.
Shouldn't that be something that we can't see? When I mean we can't see, we shouldn't be able to draw a mapping system that connects this person to that person.
I mean, so every Nigerian citizen has a right to aspire to certain positions, right? You have lawyers who have their children becoming lawyers just like their father. I mean, there's this saying that a good child would want to fit into the shoes of the parents. That's allowed. But what is the process? Do they subject themselves to the process where there are merits for those positions?
But those processes, I would want you to think that the NJC, which is the National Judicial Council, takes a thorough look at who is who. The Chief Justice of Nigeria takes a thorough look at who is who. It brings me to the question of, I remind you of something I watched growing up, Gani Fawami. Brilliant senior advocate of Nigeria. It's late now, but I mean, those are people that you would want you to be a lawyer, even if you don't have a dream of being a lawyer. You would argue. I remember one particular argument. He came out to the media to talk about how a judge should recluse himself, right, from a case because Gani Fawami could find a connection between the judge and the defendant in this case. That's the person who is being brought forward to say, come and defend yourself. But we're not seeing many judges now recluse themselves from quite a number of election-related cases. And many of these judges, I would say, and correct me if I'm wrong, because this is my perception as Nigerian, many of these judges seems to be the wife or the husband of a politically exposed person. Why is that so? Why is the NJC judicial system not saying, recluse yourself? Because there's a connection somewhere in there.
So there have been arguments that the NJC needs to do more in terms of its legal responsibilities of checking the system. But I wouldn't say there are situations where judges have reclused themselves from. I think there's a recent one with Natasha. I don't know what the reason was, but I think the first judge who was supposed to hear the matter decided, I'm not going to hear this matter, and
because it's probably a highly exposed case, but that's a civil case.
Well, I mean, it's the judiciary. We cannot pick and choose. So if you say they don't recuse them, there are examples. So it's not all that bad. There are judges within the system who are really, really doing the job the way it's supposed to be done. And it's good that we mention that sometimes. But there have been arguments that the NJC really needs to step up its regulatory duties when it comes to checking the excesses that judges and judicial officers commit during the discharge of their duties on the bench.
So for me, I hold a different view about as it relates to recusals. A judge ordinarily is billed to be able to, in all circumstances, be able to discharge his duties without fear, without favor. In a sense that a judge must be whoever comes before him. We have this principle of equality before the law. We have the principle of the due process, and then adherence to the rule of law. So a judge, to me, it becomes worrisome where we expect at every turn a judge recuses himself because he or she is if I could use your word, politically exposed. These are very, very difficult things to prove, right? In a way that the NJC has a mandate.
But I know of a judge that is married to a former governor.
So I know of judges who are wives of sitting who were wives of sitting governors, who were the wives of a sitting president at the time, and the list goes on. But it is important to give judges the benefit of the doubt, right? That they are able to discharge their duties within the confines of what their judicial mandate is. The NJC is the the oversight body for the judicial
officers.
For the judicial officers, and there's a code of conduct for judicial officers that the NJC has. So if I, as a judge, sense that because we have, for instance, we can give examples where you had the Nnamdi Kanu case and Justice Binta Nyako, and he was, I don't know on what grounds he was challenging she should recuse herself on certain grounds. If that to some extent boils down to, I would say, to some intimidation tactics, but
That's from likely the
yeah,
defendant.
from the parties. So if every party doesn't like the face of a judge and comes to say, oh, you must recuse yourself because of A, B, and C, then we have a crisis of confidence within the judiciary, which I believe we should try to avoid. So building also on the fact that the process of appointment is fraught with a lot of things that we see that are not supposed to be. Yes, the qualification is kind of vague in a way that you have a chief justice or the president of the court of appeal can nominate a daughter, a brother, a son-in-law, a brother, a son to judicial office at will, and it excludes people who are ordinarily qualified to hold those offices. So that for me is a problem that the NJC needs to look at, and I believe it's also a problem about the constitution of the composition of the if I say constitution, I believe it will be conflicted with the
legal term.
the constitution. But if I use the word constitution, I mean the composition of the National Judicial Council, where you have the Chief Justice is the chairman of that body. So I think we need to look at how some of these appointments are made. The NJC has recently brought out guidelines that includes the fact that every person who is nominated for judicial appointment, the names will be published for the public to make input. So I believe that is a step towards
input or dispute.
a step towards accountability, to say, oh no, because your this nominee A was once the wife, as you said, the wife of a past governor. I believe there's some form of it opens her up to some form of influence peddling and the like. So we need to look at how can we build trust within the judiciary, which has over the years dwindled. There's a lot of bad blood around the judiciary, as it were. So how do we improve that? So one of that is to look at how
the judges are picked in the first place.
Yes, the judges are being appointed into the judiciary.
I think he wants to back up his points further.
Not to overflog the issue, but I think even when we started, we talked about perception. Perception is a very, it's an important factor of justice, right? So justice must not just be done, it must be seen to be done. And if there are situations, this is me agreeing with all of the things that he said, but there's a reason why the option of recusal.
This is why I love hosting lawyers.
There's a reason why the option of recusal is part of the process in the first place. If there's a perception, we're all human beings. You cannot take, no matter how much of an impartial person you are, once you can draw a certain type of connection to you and the person that you are adjudicating against, especially when the connections are so strong, the other person would, in a way, feel slighted that, no, this person is a human being. Even though I trust the system, but this person, there's a tendency that he might be open or susceptible to some form of corruption. So I do believe that if the situation warrants, and it is very, very glaring that there it could be some perception of injustice, I think it is important that the judge recuses himself in that situation. That is not to say that the situation should be abused in the way. Lawyers will hold on anything. Once they see that this is a no bullshit judge, they will find a way, excuse my French, please. They will find a way to try to get get their cases reassigned. Yeah.
And when I think about the Supreme Court, which is the highest judicial panel that sits on any case, they get to decide on governors and presidents, especially elections in that level, and what they have to do and the mountain of work that they have to do. I'll give an example. 2019, the presidential candidate of the PDP, Atiku Abubakar, filed the petition after the election results, and he had a mountain of what he would describe, and I will not use the word evidence, I will just use mountain of facts that he was bringing forward to say, admitting to evidence, all that I have found to say this other candidate is not the eligible winner because of the results here, because of this, because this happened, there are cases and the likes of that. And when I did look through what he even filed and all the connections he made with regards to, this is what I'm referring to, I could imagine a mountain, no, let me use the word, a room full of paper, of documents, of facts, of connections that he was bringing before the Supreme Court to say, based on this, consider all this into evidence. How does the Nigerian judge, you're right, whether at the court level or at the Supreme Court level, even start to look at the mountain of evidence provided before them by defendants who are saying, rule in my favor, and here's my evidence why?
So it's called relevance and admissibility. So the judges at all level looks at the mountain of evidence that you have brought, and then it's what is relevant is just a molehill, and that is what will be admissible. So like I said, judges work with what is brought before them. What is brought before them must be admissible. It must be connected to the fact or to the relief that you are seeking for before the court. Right? It must be what is contested within the. So if, for instance, we're bringing a mountain of evidence on a presidential election, and then you have a civil matter that was decided sometime ago somewhere, and you have a pre-election matter that had been determined. These are not facts.
Precedents,
these are not facts. Precedents are different. Precedents kind of reinforces your argument to support why you should get a particular relief in a matter. But what I'm trying to explain is if what you are bringing is related to what you're asking us to look at, and then
the simple analogy would be, I have 10 apples and they are no longer 10 apples, and you're bringing evidence about oranges, pineapple, how it relates to the apples, and you have to explain how those two connect eventually.
Yes.
Okay. Yeah.
I think,
your thoughts on that?
Looking at it from just another perspective of it, all of that, and how there have been a lot of cries. You know, they say judicial officers do not speak, they are only seen. That means they don't come to the public and complain. So, but other lawyers, a lot of senior lawyers have opined that the Supreme Court is a bit overburdened with the work that it does. Now, why do I say that? You said a mountain of evidence, right? You know what an appeal does is that you take the records of appeal from the court of first instance. It goes to the court of appeal, right? And then to the Supreme Court. So all of the records of those proceedings are put together and presented before the justices of the Supreme Court for them to adjudicate upon. So they have to look at all of the procedures, especially those positions that you're appealing against from the court of first instance over to the court of appeal, and then, what you've brought before them. So there have been a lot of cries that, maybe not all of the matters that we adjudicate upon should get to the Supreme Court. And there should be some kind of amendment to the laws to say that, no, this particular issue should. If you steal Maggie and somebody takes you to court, for instance, in Nigeria, that particular matter can go all the way to the Supreme Court.
Really?
Yes. Yes. Every petty offense, every dispute, there's no dispute if there's anyway, there are things that you look at constitutionally.
If civil cases can get all the way to Supreme Court, then why is the Supreme Court reserved for governors and presidential cases only?
That's the perception, because those are the cases that make it to the media. But every other matter, there are people who wait 10 years for their courts to get a date at the Supreme Court.
On election issues?
Not on election, on major civil issues.
Oh, yes, civil cases I understand. But I mean, election issues are not just about the person defending. It's about the people you're trying to represent or the party you represent. So if governors and president cases only are the ones that get to the Supreme Court level, one would wonder what happens to a local government or a ward person trying to get justice for himself.
On election matters, yes, there are limits. So for maybe the House of Assembly and the House of Reps, they stop at the Court of Appeal. I think the whole idea is because during election periods, there's a limited time that adjudication.
6 months, I presume.
Yeah, that all of those cases must be adjudicated upon. If you say, it still goes back to what we were saying about how much load the Supreme Court has to carry. And because this happens in a short period, there must be an end to litigation. So the Lord has decided that some of these cases, that end to litigation stops at the Court of Appeal. Right?
Yes.
It doesn't get to the Supreme Court, just so that the Supreme Court is not overburdened with dealing with this number. You have 774 local governments, and in an election, you could have disputes from all of those 774. How many constituencies, how many senatorial districts, and you expect all of them to get to the Supreme Court.
It's a lot, no doubt.
The Supreme Court has criminal cases it has to look at. And that's why the argument is that those regular cases suffer because of political cases. Because once those political season comes, you drop every other thing and deal with those cases because they have to be dealt with within a particular period of time. So the argument is that certain cases should stop. There should be, and I like that argument.
Yes, at the appellate court.
Amendment to even the way cases from Lagos should probably have a regional.
You're about to open up on the next question I want to ask mainly, and I'm hoping you also jump into this. So, Court of Appeal. Okay, so I've not gone to your legal clinic. I'm not a lawyer, but I can imagine with 50 legal clinics, one of the questions that some of the students across the universities will be asking is, how many courts of appeal do we have in Nigeria? And the next question will be, why is it that one court of appeal gives this statement to say, oh, this is our verdict, and then another court of appeal gives another verdict, and everybody says, I won, I won, I won?
So, yeah. I don't know the number of court of appeal. I know there's one in every
region,
no, not region. I think some states have courts or divisions of the Court of Appeal. I think they're divided into different.
So it's one court of appeal, but we have different judicial divisions mainly. So a judicial division will cover, for instance, like 3 states.
Okay.
Yeah. So that's how it's built, and for the purposes of election petitions, you have. The first instance is the election, the Presidential Election Petition Tribunal. That's the first instance.
For presidential elections.
Yeah, for presidential elections. So once that is done, and it's composed mainly of justices from the Court of Appeal. After that, when they pass their when they make their decision and the parties are not satisfied, that is when it goes to the Supreme Court. So it's just two levels at the presidential at the presidential. But for the
Senate,
for the
House of Reps,
Senate,
state
House, yeah,
assemblies.
the state assemblies and the likes. So you have for instance, the governorship and the National Assembly tribunals. If they make their decisions and they are not satisfied, they go to the Court of Appeal, and then it stops at that level, except for the governorship candidate. We talk about the need for having Court of Appeal for every. You have to look at what are the logistic challenges in the Supreme Court is composed of about 21 justices at it. So they sit in panels, and as at now, the Supreme Court, you have you don't have their docket, or their docket is full from now up until 20. Yes.
Up to 28 years.
Yes.
Did you mean 28 of next year, or for the next
2028? Yeah. So you can't get a date before that. So there's always question about why do we have to get to the situation where all cases would end up in court. There are other avenues we could, for instance, resolve disputes. So he talked about civil matters and other criminal matters. There's the Administration of Criminal Justice Act that talks about restorative justice, talks about non-custodial sentencing and other alternative methods of resolving resolving conflict. There needs to be capacity, one on the part of the judiciary, to kind of adopt these mechanisms. Most of the states like Lagos, Anambra, and a couple of other states.
But that's on the recommendation part, Mahmoud. And I do not mean to break, but I'm asking about when I read in the newspaper. Mahmoud says, I won, because the Court of Appeal here said, I won. Why says, I won? Because the Court of Appeal here says, I won. And that's an election case, and they both lay claim to the victory. Why are there situations
it's like I said, it's one Court of Appeal. So I guess what you are talking about,
I mean, Court of Appeal in Enugu, Court of Appeal in maybe
you might be talking about the High Court.
The High Court.
Yeah. So
okay,
High
Court, right?
It's the
okay,
High
fine.
Court where it's a situation where you have people forum shopping.
Oh, okay.
Yes.
So there's the High Court, there's the Court of Appeal, and there's the Supreme Court.
Yes. So that's the hierarchy.
So the High Court is where everybody wins, kind of.
It's the court of first instance.
So in many matters, especially pre-election matters, as it were. So if, for instance, there are instances where a party in Enugu, in Imo State, went all the way to Kebbi or
Federal
Sokoto.
High Court.
Yeah, Kebbi or Sokoto State. No, the State High Court to get an injunction. It was a party leadership, I guess, during this the last PDP chairman.
Not Damogu?
Not Damogu, no.
Oh dear.
Ayocha or something.
Not Ayocha.
Oh dear. Okay.
Yes, one of the PDP chairmen.
Secondus.
Secondus.
Okay.
Yeah. So there was a conflicting ruling as to the subsistence of the party chairmanship in an Imo State High Court, and another one given at the I guess it was the Kebbi State High Court that went to the NJC, and those judges were actually sanctioned. So you see instances where parties.
I'm just curious. I do not mean to break in. What does a sanction for a judge look like? Because it's never been public. What does that sound like?
So it could be the NJC would kind of bar the person from promotion for a number of years.
Oh, I see.
They could stop the payment of salaries for a number of time, or that person would be dismissed, as it were. So the last meeting of the NJC, about 3 or 4 or thereabout, a number of judges from the Imo State High Court were dismissed.
I saw that in the paper.
So on the basis of the falsification of age, and a justice of the National Industrial Court was barred from promotion for about 3 years, and then a number of them were I think admonished. Yes. So those are depending on the severity of the misconduct, as it were. So a misconduct is not what people perceive; it is what the guidelines is a breach of the NJC guidelines, the code of conduct for judicial officers. So we'll feel, because Justice A nominated his son or his daughter for a judicial office, and then we say, oh, that's a misconduct, because the code of conduct does not say that is a misconduct, but we believe it's not right. That does not make it a misconduct that would pass for a judge to be sanctioned by the Judicial Council. Issues around corruption, falsification of age, fraud, and the likes are serious misconduct that the NJC looks at and sanctions accordingly. I must say.
Okay. What do we do when we start to see lobbying in our judicial system? And this is us rounding off, right? Lobbying in terms of, so they said they are lawyers. They said the man who knows the judge. I can't remember how the quote goes exactly, but there's a saying about you can have a good case, but there's some sort of lawyer who knows the judge. They do not say what happens when you do know the judge, but there's lobbying also around election issues. Some famous lawyer is standing before the judge. Probably, they have an unconventional relationship, an undisclosed relationship. But there are claims, and this is based on public perception, which means there's no real evidence to it. But there are public perception about, this judge and that lawyer probably hang out together, and that's why every time his case comes before this judge, maybe on election issues, he probably will look at some things differently than the way he would or she would, as the case may be.
Yeah, so I think I would say allegedly, because there are no.
That's why it's perception.
Evidence. Yeah, but I think those are some of the issues that have come up over and over again and have really cast a bad light on the image of the judiciary. You've had a lot of accusations. I think in the course of our work, there was a report. I can't remember the source of that report, but it kind of placed a percentage of the number of lawyers that have been seen to try to influence the outcome of cases by, this unnecessary fraternization with judges. And it has, put a bad light on the integrity of the judiciary. And this, we think, for the perception of the public to improve, these are some of the areas that needs to be worked out. And I think this is where the MBA and, the ethics committee of the bar comes in, because it's mostly a lot of senior lawyers that have been accused of this. When you said something about the man who knows the judge, it's mostly very senior lawyers that have that kind of access to judges, because, they've reached a particular rank. When you go, there's a saying in every young lawyer who practices, and you go into a court on a day and you see how a senior advocate, the kind of privileges that a senior advocate enjoys in court, you aspire to want to become that. So sometimes those type of privileges that they enjoy gives them some kind of access that other lawyers do not have. And when those access is abused, we're not saying that you've reached a particular level as a senior lawyer, you've earned those privileges that you have. But when you subject those privileges to abuses where you try to influence the system to work in your favor, that is where the problem arises. And I think this is where the NBA needs to really step up to sanction the way the NJC has sanctioned some judges for the part they play in, causing confusion in the system. Senior lawyers need to start getting sanctioned for their activities in trying to influence cases.
Okay, let me allow Mahmoud round up for us on this.
So basically, I think the issue is looking at it from the perspective of the role of the judiciary vis-a-vis how over the years there's a dwindling issue around a decrease in public trust. The decrease in trust the public has in the judiciary, especially around election cases. We look at it from the lens of how it affects civic participation, in a sense that how does the judiciary, the actions or the inactions, as it were, of the judiciary kind of shrinking civic space in terms of the ability of people to participate fully in elections, the ability of people to kind of, like you mentioned, if I'm not satisfied with the result of an election, how do I so things like that. So I would say it's important for the judiciary, as it is, to look inwards to tackle the issue of integrity in terms of how do we kind of sanitize the process of appointments of judges, in terms of how do we apply the rules that we don't allow our decisions be focused mostly on technical grounds. So because a lot of times you see a very good case is kind of
knocked out
on technical grounds, which a lot of people perceive as an injustice, and rightly so. Then also you talked about we also need to look at the issue around appointment of justices to the elections tribunal. As it is at the moment, I don't recall, correct me if I'm wrong, if there is a specific procedure for appointment of judges to elections tribunal. So that way, if there's a system that kind of looks into it to sanitize it, so that you eliminate this issue of saying, oh, because this person is related or have an interest to this person, that's why they are composed in the elections tribunal. So on issues like that, then you also have the issue around funding and independence of the judiciary, which is very key. I started by talking about the different roles of the executive, the judiciary, and the legislature. The judiciary is supposed to be independent in terms of funding, independence in terms of decision making, independence in terms of the ability to interpret rules or laws that come before them, the ability to resolve conflict without external influence. So once we have that and we put the necessary structures and the mechanisms in place, it tackles that issue, and in a way it builds back trust from the populace, to ensure that, in the next election cycle, I have the confidence to go and vote, because I know my vote would not, at the end of the day, be determined by a judge somewhere, somehow.
Yes.
It will stop at the ballot. So that is very important, and then it kind of encourages more people. Like I mentioned earlier, we had seen a drop in the number of persons who come out to vote. We hope with this, there would be an increase that opens the space for people to kind of express, give them the freedom of expression, participation, to choose who they want to lead them in a way, and then open the makes the governance structure more accountable. And then finally, in terms of judicial misconduct, the regulatory body, or the NJC has to step up to ensure that judges who are found to have found wanting in terms of any misconduct, any judicial misconduct, are sanctioned accordingly.
Certainly.
Yeah.
I have to say big thanks to you, gentlemen. We've been discussing cause verdicts and electoral choices of citizens. Yes, and of course, Mahmoud Yusuf is a lawyer, a justice reform advocate with over 15 years experience in human rights, development practice, governance, and rule of law. He is currently serving as the programs manager at the network of University Legal Aid Institution Nigeria. He's also been on quite a number of committees, Project Steering Committee of the World Bank, Legal Aid Council of Nigeria at some point in time. And of course, one could only imagine all the other parts that you represent. Who is Abdurrahman? He's a legal practitioner. I got through it safely this time around. A senior project officer at NULA, Nigeria. He was a master's of law degree from Nasarawa State University, and as project officer, he works with over 50 university-based law clinics, promoting access to justice across communities in Nigeria. He has contributed to key publications, including the Administration of Criminal Justice, Pretrial Manual Indicators and Monitoring Framework for Pretrial Provisions of Administration of Criminal Justice Act, and COVID-19 Pandemic, Human Rights and Access to Justice in Nigeria report. I wanted to say, even the report, the title of the report tells me there's so much to read in the report. And NULA extensively has worked as well on quite a number of materials. I'm sure if you go on their website, the role of judiciary is shrinking civic space and democratic decline in Nigeria. Many of these reports are available on their website. And of course, this conversation with our partners, HBS, the Erich Ball Foundation, yes, produced by Vibing Brands in partnership with Fire Radio Co. and, of course, the Volume Pod. We're glad we could bring you this conversation today. And that's it. But we actively want your comments on this, wherever you're watching it from, whether it's on the YouTube platform or any of your social media platforms of your choice. Please provide your comments. Something you agree with, something you dispute, well, it's fine. We just want your comment and your thoughts to be shared with us, okay? We're grateful that you've chosen to do that. Thanks so much for being on Matters That Matter. I'm Femi D. Amalem. Enjoy your day.